Hi guys. Florida Real Estate Sales Associate course, Chapter 7, Federal and State Pointers. Chapter 7, Pointers. Federal and state laws pertaining to real estate. Civil Rights Act of 1866. The Civil Rights Act of 1866 prohibits discrimination on the basis of race. The Federal Fair Housing Act is officially titled the Civil Rights Act of 1968. The 1968 Act expanded on the 1866 Act and makes discrimination in the showing, negotiation, sale, rental, or financing of a dwelling prohibited when based on race, color, religion, sex, or national origin. Block busting, which consists of inducing an owner to sell or list on the basis that the neighborhood is deteriorating or becoming transitional due to an influx of minority persons, is illegal. It's in the 1968 Federal Fair Housing Act. It also prohibits steering or channeling an individual directly or indirectly into or away from a neighborhood on the basis of race, color, religion, sex, or national origin. The use of a different sales pitch or catchwords that are suggestive of race, religion, sex, or national origin for different types of prospects is unlawful. The redlining is the refusal by a lender to approve mortgage loan based on a property being located in a certain geographical area, the age of the property, the income level of the residents, or the racial composition of the area. Also illegal by the 1968 Fair Federal Housing Act. Americans with Disabilities Act, ADA. The ADA was passed in 1990 with the purpose of providing the same employment opportunities to qualified individuals with disabilities that are available to persons without disabilities, and to provide access for all such persons to public buildings. Owners of properties open to the public are required to remove barriers that limit access or utility to individuals with disabilities. The ADA mandates design specifications for multifamily dwelling units to provide accessibility and usable common areas for people with disabilities. The ADA also covers employment opportunities, public accommodation, accessibility, and telecommunications with the goal of eliminating barriers that affect individuals with disabilities. Owners of existing properties that do not comply with the Act are required to make necessary modifications whenever such changes are economically, depends where you're from, feasible. Stigmatized properties. Persons with acquired immune deficiency syndrome, AIDS, immune deficiency syndrome related complex, or human immunodeficiency virus, HIV, are designated as handicapped and are afforded all protections made available to such persons. It is unlawful to discriminate against otherwise qualified individual in housing, public accommodations, or governmental services on the basis of the fact that such an individual is or is regarded as being infected with human immunodeficiency virus. Security deposits and advance rent. The landlord is required to make clear provisions for the handling of deposit money and advance rent held for periods other than the next immediate rental period. The landlord is required to notify the tenant in writing within 30 days of receiving the security deposit or advance rent as to the manner in which the landlord is holding the funds and the interest being accrued, if any. The landlord options and procedures for handling security deposit money and advance rent are as follows. Hold the total amount of the security deposit or advance rent in a non-interest bearing account in Florida banking institution for the tenant's benefit. The landlord cannot commingle the funds with any other funds of the landlord. Hold the amount of security deposit or advance rent in an interest-bearing escrow account in Florida banking institution for the tenant's benefit. The tenant shall receive 75% of the interest earned, or 5% simple interest, at the election of the landlord. The landlord cannot commingle the funds with any other funds of the landlord. Post a surety bond with the clerk of the circuit court in the county in which the dwelling unit is located, and in the amount of the total security holdings, or $50,000, whichever is less. The security deposit and advance rents may be commingled with other funds of the landlord. The landlord must pay the tenant 5% simple interest annually on the money held in this manner. Upon the tenant's vacating of the premises, the landlord has 15 days to return the security deposit, including accrued interest, if any, if there is no intention of making a claim for damages against the deposit. If the tenant violates the statute or the rental agreement by not residing in an acceptable manner, the landlord can deliver written notice to the tenant specifying noncompliance and the landlord's intention to terminate the rental agreement. In such event, the landlord may terminate the rental agreement, and the tenant shall have 7 days from the date of notice to vacate the premises. Failure to pay. If the tenant fails to pay rent when due, the landlord can deliver a written demand for payment of the rent or possession of the premises. If the default continues for 3 business days after delivery of the demand for payment, the landlord may terminate the rental agreement. Prohibited practices. In an attempt to collect rent, no landlord can cause directly or indirectly the termination or interruption of any utility service furnished to the tenant. The landlord cannot prevent a tenant from gaining reasonable access to the dwelling unit. The landlord cannot remove outside doors, locks, or a tenant's personal property from the dwelling unit unless the unit has been surrendered, abandoned, or the tenant has been lawfully evicted. Types of lease. Gross lease. A gross lease is a lease in which a tenant agrees to pay a fixed rental amount, and the landlord pays all expenses related to the property, such as real estate taxes, insurance, and maintenance costs. Residential leases are usually gross leases. Net lease and net leases. A net lease is a lease in which the tenant pays a fixed rent plus all or a portion of the operating costs, such as real estate taxes, insurance, and maintenance. Commercial and industrial leases are commonly net leases. The net rent is paid to the landlord after the tenant has paid the expenses they have agreed to pay. Percentage lease. Percentage leases are common in retail centers and malls. A percentage lease is a lease in which a tenant pays a monthly base rent plus a percentage of the annual or monthly gross sales of goods sold on premises. Assignment. A lease has 2 basic components: a period of time and a unit of space. An assignment of lease occurs when a lessee transfers all of the lease space for all the remaining time. The lessee is the assigner. The person receiving the rights is the assignee. The assigner assigns leasehold rights to the assignee. An exception to the Florida law is a for sale by owner. A for sale by owner may be contacted by a licensee to solicit the listing. Federal law prohibits telephone solicitation before 8 a.m. and after 9 p.m. Individuals may request they be placed on a federal do not call list, which must be observed by any firm using telephone solicitation methods. Violators are subject to a fine of $11,000 per call. There is no charge for registration, which is valid for 5 years. The licensee may call an owner whose name appears on a do not call list when representing a buyer interested in buying the property, but may not use the showing in attempt to obtain a listing. And that is it for Chapter 7. And there goes the pillow off the couch.